Okay, let's look at the statement of facts from the appellee and the appellant, Darlie Routier. Let's take a look. There's some things in here that I feel are important that the supporters don't consider. I'm just going to go over this briefly. It's not going to be a long video. There's only one or two things that I want to show on here. Let's move quickly down through here. The appellant was indicted for the capital murder of her son, Damon Routier, a child under 6 years of age, in cause number F96-39973J. On appellant's motion, venue of the trial was changed to Kerr County under cause number A96253. Appellant was convicted of the charged offense after a jury trial, CR 4. The trial court assessed punishment at death in accordance with the jury's answers to the special issues submitted under Article 37.071 of the Code of Criminal Procedure, CR 22021. Direct appeal to this court was automatic. Now, appellant does not challenge the sufficiency of the evidence to sustain the conviction. That means, oh no, the evidence is good. I'm not talking about the evidence. The evidence against me is good. I'm talking about how they got it. The evidence is good, but the way they got it was not good. They're looking for a technicality. The evidence and inferences viewed in the light most favorable to the verdict show that in the early morning hours of June 1996, police and fire units were dispatched in response to a stabbing call at 5801 Eagle Drive, blah, blah, blah. Okay, we know about that. The courts recognized James Cron, an expert crime scene investigator, walked through the crime scene with the Rowlett officers later in the morning of the offense. Cron's initial impression of the crime scene that there was no intruder. Fragile items in the living room were relatively undisturbed, undamaged, and unbloodied. There was no blood in the garage, and the dust on the windowsill was undisturbed, where the intruder allegedly escaped into the backyard. The mulch outside the window appeared undisturbed, and there was no blood or evidence or forced entry exit on the gate leading from the backyard. A vacuum cleaner and broken glass lay atop bloody fingerprints in the kitchen. Moreover, it appeared that someone had rolled the vacuum cleaner through the blood on the floor. Finally, blood found on in the utility room, one of the locations where the appellant claims she found the knife, was inconsistent with blood deposited from a drop knife or by a running person. A neighbor mentioned Routier's financial situation to the police. Documents recovered from the room where the murders occurred included life insurance policies on the dead boys. Documents recovered from the trash included a letter showing that the appellant's American Express account was $964 overdue, and that her mortgage was 2 months past due. Later, investigators learned that the Routiers were turned down for a $5,000 vacation loan due to excessive debt and delinquent accounts, only 5 days before the murders. The staff at the hospital believed that the appellant acted strangely. Appellant had a flat effect, while most mothers who had recently lost children were hysterical. The visible wounds on appellant's forearm and hand did not appear to be typical defense wounds, but could have been self-inflicted. Appellant described the events at her home to several different nurses at the hospital, but her various accounts contain major discrepancies regarding the number of alleged assailants, how she awoke, and where she found the knife. None of the hospital staff noticed severe blunt injuries to the appellant's arms. Photographs dated 4 days after the offense, however, show the appellant with severe bruising on her arms that it could only have been caused by readily apparent severe blunt trauma injuries received within the prior 24 to 48 hours, at least 2 days after the release of the offense. Appellant also told different stories to her friend Barbara Javelle. First, she told Javelle that she awoke when she heard Damon say, "Mommy, Mommy," and a man was on top of her, stabbing her at her throat. Later, she told Javelle that the man was rubbing the knife on her face and looked like he enjoyed it. Javelle was also present at a bizarre birthday party held at Devon's grave on June 14, 1996. A news crew videotaped the family, and they sang songs and played with silly string, laughing over the dead boys' graves. The jury watched that videotape of the party. Javelle also testified that the appellant attempted to commit suicide about a month before the murders. After the appellant was arrested, she told Javelle not to speak to investigators from the district attorney's office. Why not? And she told me that too. Why not talk to the investigators? They're trying to help you find out who killed your kids. The forensic investigation continued after the appellant was arrested and charged with the murders of her sons. Analysis of the kitchen sink by forensic serologist Catherine Long showed 7 distinct bloodstains that appeared washed out, consistent with someone washing blood off their hands. A blood transfer stain was on the bottom of the cabinet handle beneath the kitchen sink. A stain could not have been caused by that blood dripping from above, but it was consistent with someone with blood on her hand opening the cabinet. A streak that tested positive for blood was located inside the cabinet door beneath the kitchen sink. Cleaning products were stored inside the cabinet beneath the kitchen sink. Trace evidence analyst Charles Lynch found several cuts in the appellant's nightshirt that did not correspond with the wounds she suffered. Lynch also analyzed the window screen allegedly cut by the intruder to enter the house. The screen was constructed of fiberglass coated with rubber. One of the knives from the knife block in the appellant's kitchen was covered with debris consistent with the fiberglass and rubber from the screen. Robert Poole, a firearm and tool mark examiner, determined that the knife had caused one of Devon's wounds, had characteristics similar to the butcher knife from the knife block in the appellant's kitchen that she had identified as the murder weapon being dropped by the intruder. DNA testing on the sock found in the alley showed that bloodstains contained the DNA of both victims, but not that of the appellant. The toe of the sock contained faint traces of appellant's DNA consistent with skin cells shed in the sock if worn by the appellant. Tom Bevel, an expert in crime scene blood spatter analysis with over 25 years' experience, examined the crime scene and evidence, reviewed the reports of other experts, and conducted tests. Bevel examined the bloodstains in the locations where appellant claimed she had picked up the knife, the utility room, and the living room. Bevel conducted a test in which he dropped the blood knife from waist height onto the utility room floor. None of the bloodstains found in the utility room were consistent with the stains generated by Bevel's test. Bevel conducted a similar test in the living room again. None of the stains found were consistent with the stains generated by Bevel's drop test. But one stain consistent with the bloody murder weapon being laid into the carpet. They don't talk much about that bloody knife imprint on the carpet. The supporters try to, they stay away from that. A lot of us believe that Devon kicked that knife out of her hand and she picked it back up. The vacuum cleaner had bloodstains on the handle consistent with someone grasping the handle with a bloody hand. Some portions of the vacuum cleaner had bloodstains consistent with low velocity blood dripping onto it while it was upright, while other portions had stains consistent with low velocity blood dripping onto it while it was laying on its side on the floor. The kitchen floor showed roll marks caused by the wheels of the vacuum cleaner soon after the blood was deposited on the floor. The roll marks went in opposing directions, consistent with someone picking up the vacuum cleaner and rolling it in different directions through the blood on the floor shortly after the blood was deposited. Bevel also examined the sock recovered in the alley. The stains could not have been deposited on the sock if a perpetrator were wearing the sock on his foot while wearing shoes. Similarly, the stains were consistent with the perpetrator wearing the sock on his hand as a glove during the offense because none of the appellant's blood was found on the sock. See, we would expect that if that man attacked Devon and Damon first, we expect to see their blood there. And if his hand with that sock on his hand was to come down on Darlie's neck and slice it, you would expect to see blood on the sock from that slice. There was no blood of Darlie's found on that sock. That is the smoking gun. It should have had her blood on it, unless she was the one wearing it. Bevel also examined 2 small blood stains found on the upper right shoulder area of appellant's blood-soaked nightshirt. One stain was a combination of Damon's and appellant's blood, and was consistent with blood being cast off the knife as the appellant raised the knife in order to stab Damon while kneeling over him. The other stain was a combination of Devon's and appellant's blood, and was consistent with the knife being cast off as the appellant raised the knife and stabbed Devon another time while kneeling over him. Bevel also examined 2 small stains in the left shoulder of the nightshirt. One was a mixture of Damon and appellant's blood, and was consistent with being cast off with the knife was the downstroke of a stab. The other left shoulder stain was a combination of Devon's and the appellant's blood, which was consistent with being cast off during an upstroke before a stab. Finally, Bevel examined a small stain on the back of the shirt that consisted of Damon's blood. This stain was consistent with being cast off as the knife was raised up over the appellant's head. Bevel was able to recreate similar stains through the testing where he kneeled down and moved the bloody knife up and down as if stabbing a victim. Alan Brantley, a special agent and psychologist assigned to the FBI National Center of the Analysis of Violent Crimes, reviewed the investigative reports, crime scene photos, and witness statements. In his opinion, the boys were killed by someone they knew well. The crime scene was staged. Factors that supported his opinion included the absence of similar crimes in the area, that the area was generally a low crime area. The crime scene was high risk for criminal because other houses nearby, lights were on, a car was visible in front of the house, and the house was on a cul-de-sac. Alleged point of entry, the window, was intimidating because of the animal cage immediately inside the garage. Window screens are normally removed during crimes rather than cut. The route through the garage was risky in the dark. The initial focus on the children was unusual and risky given the presence of an adult. The children's wounds were dramatically different in type and severity from the appellant's wounds. And this is something that Derek Levasseur from Crime Weekly, one of the youngest detectives in Rhode Island history, he Danelle tried to tell him that the wounds were the same. And he disagreed with her. And he had a big problem with the wounds on the boys being different from the wounds on Darlie. The MOA, method of attack, was different, and that was concerning to a law enforcement officer that, Derek, to this day. That was concerning to him. And before, he didn't even know that before that, Alan Brantley had already said that those wounds were different. This wasn't consistent. Appellant's statements that she chased the intruder out was inconsistent with typical violent crimes due to the disparity in her size and the described size of the alleged intruder. What sense would it make to chase him? Dropping a weapon while fleeing is risky and inconsistent with most reported violent crimes. The location of the sock was inconsistent with a real crime because it was in the opposite direction of the exit from the cul-de-sac. That's a good point. So, Rich, I would like for you to think about this. You seem to feel like the intruder could have got out and went into that back alley, into that parking lot behind the Neals, Nelda Watts, Nelda Watts, and Gorsuch's house. You felt like he could have went that way. But why did he drop the sock the other way and then go out the front door? Dropping a weapon and fleeing is risky and inconsistent with the location of the sock was inconsistent. The children were low risk due to their ages and place in society, yet appeared to be the objects of the attack, thus suggesting a more personal motive for the attack. The wounds on the boys were personal and intentional. The wounds on Darlie were superficial and staged. The attack appeared to be a personal assault because there was no indications of theft or robbery. The maximum damage to the children, but minimum damage to the property inside the home, suggested a property interest in the contents of the home. That means they didn't tear up their house because she was material. The minimal damage in the living room and Roman room was inconsistent with the struggle between two adults. The position of the vacuum cleaner on top of the bloodstain suggested deliberate placement. The absence of blood in the escape route. Kathy will try to tell you that there was blood on the floor in the garage, but Charles Lynch tests will tell you that it was a sugary, like a popsicle. The presence of window screen debris on a knife from inside the house. The use of two knives from the same block inside the house committing the offense was inconsistent because most offenders carry weapons with them to crime scene. The placement of one of the knives back into the knife block suggested propriety interest. Jewelry was in plain view. Danelle, jewelry was in plain view. Not that story that you gave that I was laughing while you told me that, by the way. Oh no, they couldn't see it. They weren't in plain view. No, there were 3 2-liter bottles covering them up. But the crime scene pictures show that the 3 2-liter bottles were way far away from where the jewelry was. But she wants you to believe they couldn't see it. The intruder couldn't see that. He could see the knife. He could see the knife block, but he couldn't see that jewelry. He sure the fuck did see it. And a wallet. And the keys to the Jaguar. The killing of the children was inconsistent with a sexual assault attack because children are usually used as leverage to control the object of the sexual assault. Appellant presented testimony from family and friends who generally described her as a good mother who was not depressed and who grieved appropriately for her dead children. See, they always say there's no way to appropriately grieve. You know, there's no way, but they always try to say she did it appropriately. Some of the appellant's friends and family testified that they saw bruising on her arms in the hospital. Yeah, Sherry Moses' testimony. That's because Sandy Aikens was writing down notes of what they were talking about. Appellant presented testimony about an attempted burglary in Rowlett on the night of the murders. Darlie Routier disputed the state's evidence that the family was in financial difficulty, but admitted that business had slowed. He was behind on his taxes, was behind on his office rent, and had large credit card debt. Appellant presented expert testimony from medical examiner Vincent DeMaio that her wounds were consistent with offensive wounds made by and inconsistent with self-inflicted wounds. DeMaio agreed with the state's suggestion, however, that the bruises on the appellant's arms could have been caused by trauma inflicted after she left the hospital. DeMaio also testified that he did not receive believe a person could sleep through the knife attack or blunt trauma sufficient to the bruises on her arms. Appellant presented expert testimony from the psychologist Lisa Clayton that she did not fit into the categories of mothers who killed their children. Clayton believed that appellant suffered from traumatic amnesia due to the attack. Appellant testified in her own defense. Appellant claimed that she woke when Damon said, "Mommy, mommy." Appellant saw a man walking away and heard glass breaking. She followed the man and saw him walk into a utility room. Yeah, so this brief, and I'm not going to read the whole thing, but it's really interesting, and it's a big read. But it starts out with, the thing that's concerning to me is Darlie doesn't even contest the evidence against her. She agrees with the evidence against her. She agrees with it. She agrees with that. So what they're looking to do is get her out on a technicality. If Darlie doesn't contest the evidence against her, then why the fuck are you supporters doing it? Need to look for a loophole to get her out of there. Not because she's innocent. And one day you guys are going to see this. You're looking for a loophole. Yeah, it's really go on Facebook to the Darlie Routier War Room and look in the files section. You can read this whole thing here. The supporters don't talk about it much. They really don't. Justice for Devon and Damon.